you may sound the first case.
S14A 1705, Marta Corky versus the state, Andrew Fleischman for appellant, Thomas Miles for appellate.
Yes, sir. May proceed when ready.
Thank you, Your Honor. May it please the court, my name is Andrew Fleischman. I represent Marta Corvey, the appellant. This will be my first oral argument, but I hope I can be of service to this court this morning. The state's primary argument in this case is that the issue was waived. I would like to address that before I move on to the merits of the case. The state has argued that at no point was the constitutional void for vagueness issue raised at the trial level. However, a motion to quash the indictment as void for vagueness was filed. A brief in support of that motion was filed. There was a 20-minute hearing on that issue on May 21st, 2013. The judge ruled in writing that the statutes were not unconstitutionally void for vagueness as applied to this case. At the motion for new trial, the judge complained that I was once again bringing up void for vagueness as applied. The state wrote a proposed order saying that the statutes were not void for vagueness as applied. Under that standard, Your Honor, I believe the issue has been sufficiently raised for this court to address it. Ms. Corvey was not so much a criminal as a tragic figure. That's what the trial court said. The evidence was insufficient to convict her, and she could not have known that the law prevented a parent or caretaker from leaving two 5-year-olds to play in their room. Your Honor, the evidence was insufficient because in Georgia, in order to convict somebody for a foreseeable accident with a child, you need one of two ingredients. You need permission of the parent, or you need propensity. And that's present in every criminal case cited by the state. In Kane v. State, a mother was routinely warned not to leave her children unattended, yet she did so. Daily, her 1.5-year-old, her 2.5-year-old were found outside. Neighbors shut her out of their house so she would stop leaving her children unattended to use their phone. She had 2 years of parenting classes. At one point, in fact, one of her children suffered chemical burns because she failed to supervise the child. That is the case that the state says is functionally identical to this case, not because the conduct was similar, but because in both cases, 2 young children drowned. In that case, of course, those children had permission to be outside, and the parent knew their propensity to leave the house. Baker v. State is probably the state's best case here. In Baker, a father left a 9-month-old teetering at the top of a flight of stairs. He left a 3-year-old to sleep in bed, and he left the house.
Mr. Fleischman, are you saying that Baker is your best authority on this point?
I'm saying that it's the state's best authority on this point, Your Honor, and I'm addressing it and distinguishing it. Baker v. State held that the father was on notice that leaving those children in that dangerous situation violated the reckless conduct statute. But at that point, Your Honor, it was because he gave that child permission to be at the top of that flight of stairs. He moved that child, that 9-month-old, to the top of the flight of stairs, and he left. He left the door locked behind him. Police had to break in as the panicked mother wanted to return to her children. This court said common sense says that is violative of reckless conduct. That is criminal negligence. But, Your Honor, this case is different. Ms. Corvey did not give those children permission to leave the house. She didn't have any awareness of any propensity on their part to leave the house, to disobey instructions, to go swimming. It was raining and they were fully dressed. She went downstairs to the basement to take a phone call to take her diabetes medication. She informed a 13-year-old on the main floor of the house that she was going downstairs, and there was a reason she did it. It was diligence. It was some effort, however slight, to avert an accident. Without knowledge that those children would go downstairs, past Nawel, the 13-year-old, and into the pool, it could not be said that it was reasonably foreseeable that this accident occurred.
Help me with this portion of it. We're in the area where we deal with the caretakers for children. That type conduct is going on every day, every hour of the day. Usually in this kind of case, we have some egregious conduct on the part of the caretaker. There seems to be an absence in this instance. If we affirm this case, in the absence of egregious conduct, what will be the consequence of such an affirmance?
The consequences are dire, Your Honor. Caretakers in this state, both businesses and private individuals, rely on the civil case law that has existed in this state for the past 100 years to say that when you are supervising a child, you have to know something about that child to present a particular danger before you're held liable for what happened. And this case, Your Honor, is much closer to strict liability. If we hold that Ms. Corvey is criminally negligent, then we must also hold that the parents in the civil cases I have cited are criminally negligent. I'd like to talk about that because the conduct that Ms. Corvey engaged in this case likely would not have survived summary judgment in a civil context. And for that, Your Honor, I'd like to first point out Doe v. Andujar. In Doe v. Andujar, a 13-year-old was left alone in the house with a 5-year-old. He wasn't explicitly told to watch the 5-year-old. The parents simply left him there while she attended to some other business. And the 13-year-old, who had a history of prior improper sexual conduct, molested the 5-year-old. And the court held that that was not negligent supervision. The Court of Appeals said that it could not be anticipated that that would happen. Bunn v. Landers, you have two parents or two women sitting in the kitchen talking to each other, drinking coffee. Not an important task, certainly, but something that everybody engages in. And in that case, Your Honor, two 8-year-olds played in another room. They didn't hear it, they didn't notice, but one of them decided to drive the other one in a go-kart down the street, and one of the children was killed. Now, the parents of that dead child sued. They were upset. It was a tragedy. But the Court of Appeals held that without some knowledge that these children would go outside without permission, that they would use this go-kart without being told, some knowledge from the parents' part that the children had actually gone outside.
Can I ask you, some knowledge, you don't think there's common sense knowledge that if you leave young children completely unsupervised, there is a risk that they will do something that harms themselves or others?
There might be a common sense inference like that, Your Honor, but in case after case in civil contexts, courts have held that, for instance, letting two children go into a tool shed where they might grab tools is not innately negligent.
Okay, but just so your one limitation that you must know the children have a propensity to do something, that would mean that unless it's basically kind of the dog gets a free bite rule, that unless the children have already gotten themselves in trouble, you could never be liable. So I could leave my 1-year-old alone in a house for a week, and you would say, well, you didn't know because you'd never left the child alone. That doesn't seem to be the right rule.
It isn't the right rule, Your Honor. What we're talking about here is really conscious disregard of a known or highly knowable risk of heavy harm. So there might be some risks in leaving two 5-year-olds to play in their room. They might make a mess. One of them might hurt the other one. But is the implied risk that they will leave the house and go into a pool when there's no evidence they've ever done it before? When you don't even know from the record whether they can open the fence? I think that that is a different matter, Your Honor.
Well, and let me ask, if Ms. Corvey, instead of going and getting on a phone call in the basement for 45 minutes, had gone in the basement for 6 hours, leaving the 5-year-olds completely unattended, and something had happened, whether it's going in the pool or turning on the stove or having something fall on them, or all of the other things that young children can do that get them hurt, would you say it's the same rule because there had been no prior problem with the children?
I'd say the length of time does go to the liability for the children to get into trouble. So, for instance, if you left children alone for 6 hours, more stuff can go wrong. Kids can get hungry, they might eat or drink something they're not supposed to, and you might have a good argument there, Your Honor.
And then the question is, if it's a matter of all of the specific circumstances, why isn't that a jury question?
I guess, Your Honor, because traditionally in Georgia we have taken that question away from the jury, just as we did in Hall v. State. In Hall v. State, of course, an 11-year-old was left in charge of a 1-year-old, a 3-year-old, and a 5-year-old for 4 hours. Conduct that, at least to me, appears more egregious than the conduct in this case. And in that case, Your Honor, this court held that she couldn't be held to know that that was innately dangerous to the extent that she should anticipate serious harm. And the reason for it, Your Honor, is something that's present in this case as well. Parents do that sort of thing every day. If we criminalize that ordinary conduct and then enforce it only sparsely, which is the case in this state, there is no other case with similar facts to Ms. Corvey in Georgia.
Mr. Fleischman, the gravamen of your argument is just simply foreseeability issue. Is that not correct?
On sufficiency, the argument is foreseeability, Your Honor.
So is the argument that you're making, you start off talking about unconstitutional for lack of for vagueness purposes, but it sounds like most of your argument goes to sufficiency of the evidence.
Well, because of the doctrine of constitutional avoidance, I wanted to talk about sufficiency before I moved on to void for vagueness, but at this time I will move on to the merits of the void for vagueness argument. Your Honors, people of ordinary intelligence might very well not know that this conduct was criminal, and probably the best evidence of that is the fact that in Georgia, we have an entire set of doctrines for children who drown in pools while unattended. We have parents who swear under oath, I wasn't watching the child for 20 minutes, as in Lofton, or I was on the phone and the child ran out the house, as in Renaud v. Black. Those attorneys have parents swear under oath that they were not paying attention to their child, that their child was in another room, that they were distracted, that they were human, and they do it without fear of criminal liability. Why is that? Because the law in Georgia up to this point has not supported a conviction for conduct like Ms. Corvey's. Further, Your Honors.
That, though, is, I'm still, the distinction between your sufficiency argument that the evidence is just insufficient, I'm looking at a statute that uses well-known legal terms, and I don't see why that would be void for vagueness. I mean, I know we applied it in Hall, a decision that was 4-3 and that has never actually been followed by either our court or by the Court of Appeals. But I mean, I don't see anything in this terminology. If we say this is void for vagueness, I don't know why we wouldn't say the Georgia tort statutes that impose liability for negligent conduct, why that isn't void for vagueness. And I know of no tort case that would ever apply that kind of principle.
Well, Your Honor, typically void for vagueness is more strictly enforced in a criminal context than in a civil context because, of course, the consequences are so much higher. And the reason why we might go ahead and apply a void for vagueness doctrine here is that when we're talking about criminal negligence, negligence that we know is especially egregious, as Justice Benham noted, we're asking people in their ordinary lives to make decisions about what they're going to do, how they're going to care for children. Somebody reading these cases might very well not know that a prosecution could follow, that strict liability could ensue once they left those 2 5-year-olds in their room.
It's not strict liability. I mean, strict liability would be a rule that says if you do this, this results. Mm-hmm. I mean, the statute, and I assume the courts charge the jury in the language of the statute uses terms of negligence and conscious disregard and substantial risks. I don't know how you get from that to strict liability.
Your Honor, I think I was being rhetorically imprecise, and I apologize on that. Moving through the case, another serious problem is that there really are not any standard enforceable practices for reasonable supervision that appear in the statute that someone might guide their behavior by. By contrast, if you look, for instance, at Oregon statute, it says if you have a child under 10, you can't leave that child unattended in a way that might cause that child harm. And there, Your Honors, they actually looked, just as I hope this court will, at what standard practices were. So in State v. Negrete, you had what was called a fearless toddler, a 3-year-old who ended up wandering down the street in nothing but rain boots for 45 minutes while the parents slept, was returned home, and then left the house for 35 minutes. Now in that case, the court said, well, gosh, this doesn't seem like criminal liability because this is something that ordinary parents do all the time. They fall asleep. They don't keep their children in constant watch. Now that case was, of course, not a void for vagueness case, but the fact that they spoke about the societal norms of parenting does speak to the conduct in this case, does speak to what a parent or a caretaker taking care of a child might expect in the course of supervising a child. This conduct, in this case, seems particularly arbitrary because, as in Hall, there was a tragedy first. This isn't like Baker, where someone walked into a situation and said, looking at this situation, it's obvious this is a bad father or a bad caretaker. This tragedy happens. You have a family that's devastated. In fact, the jury heard that one of the parents attempted to enter into a suicide pact with the other one. And after hearing those facts, of course, anyone would be moved. And here you have no clear, explicit standards ahead of time, saying, for instance, how long can you leave a child unattended in the same room? You have only the norms that we all try to abide by. And if we're going to say that we're going to enforce this law now, what does that mean for others? What does that mean for a single mother, for instance, who might want to sleep for 45 minutes or take a personal phone call she doesn't want her children to see? Can she leave her children in another room? Or do we have to look at the totality of the circumstances? Must she check for every danger in the home? I don't think that supports the goal of the statute. In fact, when the statute was passed, people worried about vagueness. The legislators said, we'll let prosecutorial discretion handle that. We won't prosecute every parent for disciplining their child. When we talk about criminal negligence, we're talking about leaving a child in a hot car or alone for a weekend. But here we are, inching towards a case where it seems like parents have more and more duties and responsibilities.
What would this statute need to say in order to avoid a void for vagueness challenge, successful challenge?
I think an ideal statute might say something like, a parent shall not leave a child under the age of 8 unattended for more than half an hour. That might be a good rule of thumb if you want to go ahead and establish something that people can abide by. Or parents are expected to be within a certain distance of their children for most of the time.
The problem with statutes like that is they're both under-inclusive and over-inclusive. You pick an age, you pick a particular time or distance, and that, under the circumstances, might be grossly negligent or it might not be. And I don't know why we've never constrained legislatures to say you must define dangerous activity, whether tortious or criminal, by laying out the specific facts that are going to be violated. We let legislatures use terms like consciously disregarding a substantial and unjustifiable risk and gross deviation from the standard of care. And those are everyday legal terms. And it seems like if we say this is void for vagueness, or if we even say this isn't a question for the jury, we're either going to decide this case and then arbitrarily limit it, like we seem to have done with Hall, or we're going to open up the world of tort and criminal liability to void for vagueness challenges. What's the limiting principle?
The limiting principle, at least in tort, is that courts have for some time already been doing this. That's what summary judgment is. They look at the facts and look to see if a reasonable jury could find by a propensity of the evidence whether this thing occurred. And Justice Carley's complaint about the void for vagueness challenge was really that it was something like summary judgment. But here, Your Honor, we've come after the trial, we've let the facts come out, and I don't think we've created any great harm by arguing that sometimes conduct that may, on the face of the statute, appear to be included should not be as a matter of prosecutorial discretion. At this point, Your Honor, I'd like to reserve the remainder of my time.
You may do so. Before you move on, though, let me note that sometimes when we are in unfamiliar territory, people are afraid of the microphone. And let me admonish everyone else that's going to speak, don't be afraid of that microphone. Go ahead and speak assertively in it. We can hear you a lot better. There's a little bit of an echo that's generated by that. So don't be timid about speaking on the microphone.
Thank you, Justice.
Thank you very much. And we'll reserve the balance of your time for rebuttal. Mr. Lyles?
Thank you, Mr. Chief Justice. May it please the court, my name is David Lyles, and I represent the people of the state of Georgia. I'm a senior assistant district attorney in the Paulding Judicial Circuit, and this is also my first time before you.
Speak authoritatively into the microphone.
Yes, Your Honor.
All right.
The appellant in this case claims, if you boil it down to one simple thing, that the trial court erred in finding the defendant had fair notice that it was unlawful to leave 2 5-year-old children alone, unsupervised, for 45 minutes with the back door open to a pool below, which the children had already expressed an interest in getting into on that very day. This court has held there are 2 grounds to hold a statute void for vagueness. That is, by failing to provide notice sufficient to enable an ordinary person to know what conduct it prohibits or requires, and by authorizing or encouraging arbitrary and discriminate enforcement. And in this case, neither of those is present. All that is required to withstand a vagueness challenge is for the statute to convey a sufficiently definite warning as to prescribed conduct measured by common understanding. And that is from the Douglas v. State case, and all of the cases that I will cite today are included in the briefs, Your Honor.
But every one of these cases is very fact-specific. Isn't that
Yes.
correct?
Yes, Your Honor.
So how can there be adequate warning to everyone who has children or who cares for children that their conduct may be deemed reckless or in violation of this statute?
There are 2 things that are consistent in every opinion that I have read that this court has issued and that the Court of Appeals have issued. regarding this issue. There are two things present. First of all is the proximity of an imminent danger. There's something there that is a dangerous instrumentality. In this case, you have a pool. In the Reyes case, you had a road where a child was wandering completely unsupervised in the middle of the road and was attacked by an animal. In the Baker case, you had children who were left at the top of a flight of stairs, unsupervised again, with no guardrail, with nothing there to keep them from coming down. So the first thing is the imminent danger. There's actually a foreseeable danger there. The second thing is they are left completely unsupervised, and that is what distinguishes this case from the Hall case. In the Hall case, you have an 11-year-old child, which the family was left, or the children were left in the care of that 11-year-old child. And this court held in a split decision that was insufficient. So it was insufficient to put the parent on notice that leaving the child with the 11-year-old child or in his supervision was not sufficient. Now, in this case, the appellant has attempted to bring in Noel, who is the 13-year-old son of the Juarez family, as a person who was left in charge as well, and that simply is not the case from the evidence that is in the trial court record.
Mr. Wells, let me ask you this. What case that you cite as authority is closest factually to your assertions and that you rely on most in this particular argument?
The closest as far as factually and assertions would be the Kane case, Your Honor. It also involved the drowning of children inside of a pool or in a swimming pool who were left unsupervised with that pool there as well. And again, you have both of those elements present. You have the drowning issue, you have the close proximity of danger, and I believe I said a swimming pool. I believe it was actually a sewage retention pond that was a short distance away from the property that the children drowned in the Kane case. But you had the retention pond, which is an imminent danger to children. Certainly children of that age were curious. And you had absolutely no supervision, which is exactly what you had in this case. And Justice Benham alluded to earlier with a question to my colleague about there being no egregious act in this case, and I respectfully would disagree with that. Ms. Corvey got on a phone call and left those children unsupervised for 45 minutes, never checking on them, having absolutely no idea where those children were, and left the back door open to the swimming pool during that entire time.
You said she left the back door open. Do you mean the door was open, or do you mean it was unlocked?
The door was wide open, as she testified to. What Ms. Corvey did on that day was she had cleaned the floor, and it was her custom when she cleaned the floor to open the back door to air out the house so that the chemical smell would not be so strong in the house. She had left that back door open on this particular day. The only thing standing between those children in that swimming pool was a small gate with an easy latch on it, which the record, I believe, also supports those children knew how to open that latch. And
Any proclivity on the part of those children to venture out in that area in the past?
I think the question of proclivity in this case comes down to what their interest was. They had already expressed an interest on this day to go to the pool. They had already asked to go outside and get in the swimming pool. They had been told no, and then she left it at that, assuming that children would simply obey whatever she had said. She left the back door open. She left them an absolute easy way of getting in and out of that house.
But had there been a pattern of them going to the pool when they'd been told not to?
I don't believe there had been a pattern of them going to the pool when they'd been told not to. First of all, because Mia Penoyer, who was the child visiting, was only there for the second time. And I don't recall whether or not she had been in the pool the first time she was there. I don't know, or it is not in the record that she had ever been there unsupervised with Mrs. Corvey on her own, and I don't believe that she had. So this was the first time that she had supervised them on their own. They hadn't all been there as a family.
There's some evidence cited in your brief that when Mia came over the night before, her father expressly told Miss Corvey and the parents in the home that Mia couldn't swim, and he had brought flotation devices and asked them to make sure they kept an eye on her?
That is correct.
With regard to swimming in particular?
Yes, that is correct. In fact, the father of Mia Penoyer had gone so far as to actually blow up the flotation device in the presence of Ms. Corvey and the Juarez family while he was explaining to them that she did not know how to swim. So there certainly was an indication that she may be interested in doing that, and certainly that she did not have the capability to be in that pool unsupervised.
Was there any evidence as to if the back door had been closed, whether these 5-year-olds were capable of opening it?
It's my understanding they were. There was some discussion on the record about the door in the basement having a lock on it. They were not able to negotiate the deadbolt lock in the basement because it was one that required a key, I believe. So we had talked about that as far as them being able to negotiate. However, they were able to negotiate doorknobs. They were able to negotiate a basic lock system. They were able to negotiate the gate that was on the deck that led down to the pool.
So that the back door was open as opposed to closed or even closed and locked is not a terribly significant factor. Would you agree with that?
I don't necessarily agree with it because I think it leaves the door open. It's even easier for them. It's even more access to them. The other thing that was debated back and forth is that there was an alarm system on that door, and that was part of the trial court's record. There was an alarm system that actually chimed as required by law anytime that door was open, which would have alerted someone in the house that someone was going out that door. And it was completely negated in this case because the door was left open. So that measure of preventativeness was completely negated in this case, or it was completely removed, which left no obstacle for these children to simply wander down and get into a pool they had already expressed an interest in getting into.
How long is too long for a parent to leave 2 5-year-olds playing in their bedroom without actually having eyes on them in these circumstances when you have a